I went to law school in South Africa in the 60s, and the best teacher was the criminal law teacher. It just seemed to get my attention and was clear and exciting. And then I started to realize how bad apartheid laws were. And so there I was teaching after law school. I was taught for 2 years in Johannesburg, and then I was teaching criminal law and other subjects. But I realized that for me, the whole focus in that oppressive regime was on power of the state against the individual, racialized people in that particular context. And so obviously there was a sort of civil rights component of what I was going to spend my life trying to do. If I'd stayed in South Africa, I would have been locked up with some of my more adventurous colleagues. So I left and I went to England, and then I came to Canada. And so always my engagement has been with anything to do with criminal law. It's all about power against the individual. And there's some very lively lawyers involved on both sides, and lots of judges who care. And then, of course, we've got the Charter of Rights and Freedoms since 1982, and that has by far the biggest influence on criminal law than any other area of the law. So that's what I concentrate on all the time. I think that one thing unusual about criminal law is that all the best minds are actually in the courtroom. And that's where things are fought out. And when your new charter standards are arrived at in the Supreme Court of Canada, for example, it's gone through 3 levels. And what I like to teach is that you have to raise your level when you're in law school and you're a criminal law keener and you want to do it. And it's not just vague stuff. You've got to really work at it. And one of the real troubles with criminal law is that I don't think people realize how many cases come down the pipe. I mean, in Supreme Court of Canada, hands down about 100 cases a year, 50 of them are criminal. And they change, and the personnel up there changes, and it's difficult. And I sort of try to emphasize that the best time to develop your expertise, whether it be criminal, substantive law, or evidence, or procedure, or sentencing, is at law school. Because when you get out into practice, whatever role you are in the criminal justice system, you're very busy. So it's hard to, so I enjoy try to be tough, and also like to raise at law school other aspects. You know? Not everybody's pro-accused, to say the least. And so that's an interesting area to explore. I think I'm unusual in the sense that since 1982, I've been editing the criminal report. So I get all the cases that are handed down by judges in criminal law to my desk in a hard copy. So I can't tell you how many that is. It's like 400 a week. And so I sift through them and throw a lot out. And then I also work that's for the criminal report. So we summarize the leading cases, which we choose with a group of 6 academics, and then comment on them. And the same thing we do for judges in a thing called the National Judicial Institute e-letter. And that's where we reach more than 1,000 judges, which I think is a privilege. So that's what I do. So I'm really doctrinally invested. I think we try in that work to write short, which is useful. I think lots of people who are doing research, especially American style research, you can't write anything till it's 70 pages long and then nobody reads it. So in our particular case, we probably write more like 3 or 4 pages or something like that. And I do think we have an influence, otherwise I wouldn't be doing it. So do my colleagues. And it's exciting. We're a group of 5 who've been together doing this work for some while. I mean, I don't know if anybody remembers here Lisa de Fremont, who's a big close friend of mine. I'm still in contact with her, and she's one of the members of the team. She says she talks to me here at Queen's more than she does for anybody at Osgood still. So it's good, and that's very exciting. So I think that what I'm trying to do is to write. I do write books. That's where it's eventually going to end up. So we have 3 co-edited teaching books in each of those subjects, and then have 2 textbooks. And the law and criminal law changes so much that you really need to do a new edition about every 3 years. And that keeps me well out of trouble. So it's a lot of hard work. And it's amazing to me that I also have this view that the people who are really good in criminal law, defense counsel, or Crown, or judges, most of them do their own work. It's not sort of shelved out to somebody else. And so I'm old stage in that way too. I hardly ever use research assistants. I mean, I do have the luxury that all the cases are coming in my direction anyhow. But and so I can get to look at them and get 100 cases and throw away 90 and keep the others and never look at the 90 again. So I think one of my challenges, and I'm certainly near to retirement, one more year, I will carry on writing and doing this kind of research because I think it actually helps the profession and helps some of the judges. No doubt some of the lawyers involved in the criminal justice system think that I've got my biases, which I certainly have, and sometimes they listen and sometimes they really don't. So there you go.